Hi everyone, this week's video we'll be looking at reform of the employment tribunal system. So a roadmap was first published in 2020 in June to respond to the adaptations that had been made during COVID, essentially moving as much online as possible. A strategy was put in place for dealing with the challenges presented by the pandemic and with longer term reform in mind. We're at the stage now where there is an acceptance that we will not return to the pre-COVID position in the employment tribunals, so there will not be in-person hearings in all cases moving forwards. At the moment, the majority of hearings in the United Kingdom are continuing to take place on a fully remote basis. 90% of full hearings are still by video. And there is a desire to bring that percentage down. There are a number of benefits to video hearings. So cost is reduced. It's often the preference of the parties, particularly in more simple cases, maybe where there is not a huge amount of evidence. And they're less disruptive as well. People are having to travel to different locations. There's all sorts of disruption that can be caused by that. So the position from the 1st of April 2022 in the current roadmap now suggests preliminary hearings will continue to default to telephone or video where they are administrative in nature. So typically these are case management meetings to timetable out the rest of the case in terms of disclosure of documents and statements. There is no reason why those need to be in person. Preliminary hearings to determine a straightforward issue such as time limits in an unfair dismissal case will continue to default to video. If there is particular complexity to the evidence, possible impact of the Equality Act, that is one consideration which may suggest it's more suitable for an in-person hearing. Applications for strikeout and deposit orders will be done remotely where possible. Judicial mediations, which are normally appropriate in complex, long-running discrimination claims to try and settle matters, they will continue to default to video, which I find quite interesting, but that seems to be the most appropriate way. And short-track claims, so these are smaller claims, maybe relating to wages, notice, holiday pay, enforcement of basic contractual rights, will be remote wherever possible. And that can tend to be the majority of the caseload. So unless, again, there is particular complexity, the aim is that they will be heard on a remote basis. Final hearings of standard track claims, so unfair dismissal being the most common, will vary. In the event that premises can open across the country and in different tribunals more quickly, it's expected that we will be able to get back to more in-person hearings. The problem is those tribunals that have a very significant backlog, it's likely that these cases will be listed on a remote basis just to get the backlog down before we can then consider scheduling remote in-person hearings in place again. Open track claims, so the much more significant complex ones such as discrimination, whistleblowing, perhaps a chunky constructive dismissal claim, will default to in-person. So again, backlogs and capacity continue to impact on that decision, but the aim is that we will go back to in-person hearings, which was the pre-COVID position. It will always be open to an employment judge to decide that those rules might not be particularly applicable for whatever reason, and that may change the format into a fully remote case, or maybe one where a hybrid approach is taken. The other aspect of tribunal reform I wanted to focus on was some minutes that were published in March, which is in relation to the tribunal user group meeting. One of the key issues is still waiting times. So just to give you some information, all regions can list shorter hearings of 1 to 2 days duration in 2022. So that does appear to me to suggest the backlog is coming down in relation to shorter claims. And some tribunals, particularly in the northeast, can even manage the first half of 2022. So we are getting back to a position where short track cases are being heard in a matter of months, which is very positive. But for longer hearings, the picture is much more varied. Shortest waiting times again in the northeast, and cases can still be heard before the end of 2022. The issue is in other regions such as Midlands East, South West and most parts of the South East. Cases are now being listed for the first half of 2023. So if you are facing a claim imminently, or one is in progress and hasn't been listed for a hearing date yet and is in one of those regions, there's going to be a significant delay on listing that for hearing, and that can impact on your approach to the case, approach to settlement and the like. The longest wait times are in London, London South, London East and the North West. 3 to 5 day hearings, mostly listed in the second half of 2023. And for cases lasting 10 days or more, London South and the North West are now listing for 2024, which is a huge delay. And that does affect the quality of evidence, because we're wanting witnesses to recall incidents which may have happened some 3 years earlier. Other points to note within those user group minutes, the cloud video platform, that's the platform that's used for the remote technology in the Employment Tribunal, is likely to be replaced during 2022, and there is a timetable for that under discussion. There is also an FAQ document that the Courts and Tribunal Services has published relating to reform of the process. There will be a release of online portals which will be limited to litigants in person to start with, and there will be access for legal representatives ultimately on that platform as well. There will be improved ET1 and ET3 forms for the claim and response form, and access to online case progress updates, and the ability to make applications digitally. So the expectation is that not only will hearings become remote, but the actual operation of the claim and progress of that claim, right from issue up to hearing date, will be done as much as possible through an online portal, bringing this into line really with other technological developments in the legal sector. So hopefully that gives you a good overview of the way forward in the employment tribunal system. We do have a specialist employment litigation team here, so if you do need anything on that front, please do get in touch. Visit the website www.chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.